So a birth injury claim is a title given to claims that represent when an injury has been caused either to a fetus, an unborn baby, the baby itself, or a mother, either during pregnancy or labour. It can cover a wide range of cases, from very serious brain injury cases in the baby through to the mother having either vaginal tears or episiotomies during the actual delivery itself. The most common injuries which can occur to the mother during a birth injury are often in relation to vaginal tears or episiotomies not being performed correctly, and this can also sometimes have a consequence of a psychological injury to the mother as well. In relation to the child, one of the areas that we come across very sadly is when there's been a hypoxic brain injury to the child, sometimes as a result of an infection, or they're being distressed during the labour, which is called a hypoxic brain injury. This can go on to manifest itself as cerebral palsy. Another type of injury that we sometimes come across is Erb's palsy or shoulder dystocia, when there's been some difficulties delivering the baby, and either this has caused an injury to the shoulder and the nerves in the neck, which can cause permanent damage. Sometimes this is caused by excessive pressure being used during a ventouse or a forceps delivery that can cause quite permanent and severe injuries. Birth injury claims when there's been an injury to a newborn baby are one of the very few areas that are still entitled to legal aid funding. So if a family wish to investigate a potential claim for a birth injury claim involving their baby, where a brain injury is being suffered, I would recommend that they seek a firm of solicitors that's got a legal aid franchise. The process for getting a legal aid contract is very vigorous. There's a lot of vetting that takes place by the legal aid authority, so it means the firm of solicitors that you're going to will have the expertise and experience to bring these very complex types of claims. The solicitor would be dealing also has to have accreditation either by the Law Society or a separate organisation called AVMA, which again just confirms that both the firm and the individual solicitor who will be handling the case have the appropriate qualifications to be able to deal with these quite complex cases. In the alternative, you may be able to find a solicitor who will investigate matters on a no-win, no-fee agreement, or alternatively a conditional fee agreement, but there are likely to be some cost implications for this in relation to an insurance policy that will need to be taken out, and also potentially the solicitor may speak to you about a success fee being deducted from the compensation if the claim is successful. If legal aid is available, this would avoid the need for deductions to be made in relation to success fees and an insurance policy. So it just means there's no deductions made to the compensation at the conclusion of the case for those reasons. It's very difficult to give an average figure, and it probably wouldn't have much meaning. Every single birth injury case will be different, and the amount of compensation that's awarded would be directly proportionate to the level of injuries and the amount of care and additional needs that are arising from that. For some very serious cerebral palsy cases, you will often see compensation of many millions of pounds being awarded, but it has to be remembered that the child in these cases will often have lifelong needs, and we need to ensure that they've got the care and assistance they need, not just for now, but for the rest of their life. Sometimes those cases are settled on the basis they get a lump sum of damages and then an ongoing payment of compensation each year for the rest of their life to compensate them for the care that they will need, just to ensure that they don't run out of potential money in the future. Going to the other end of the scale, the amount of compensation that may be awarded for injuries to the mother may be a 5, potentially a 6-figure sum, but it will all be representative in relation to the injury that they've suffered and what needs they have as a result. So the time limit for a mother to bring a birth injury claim would be 3 years from either when the injury occurred, or alternatively the knowledge that the injury had occurred if that was a later date. In relation to children, the time limits are a little bit different in as much as the claim needs to be brought within 3 years of their 18th birthday, so effectively before they're 21. In some birth injury claims, the nature of the injury is such that neurologically they've got damage, which means that if the person doesn't have capacity, the time limits don't apply. So a claim can be brought many years after the child reaching 21 and they would still be in time. So the expert evidence in a birth injury claim is crucial. If it's a claim looking at an injury that the child has suffered as a result of a complication during pregnancy or labour, then very commonly you'll be looking at a report from an obstetrician to look at the standard of care that was provided, or alternatively a midwife if there's criticisms of the care provided by any of the midwives. And then in relation to the causation or consequences of that harm, very often you'll need a report from a paediatric neurologist or a neonatologist to see if we can say that if the standard of care hadn't been breached, would the injuries have been avoided.